Privacy in the age of generative AI. Hello and welcome to 39 Essex Chambers AI and the Law podcast series. I'm David Mitchell, and in this episode I will be discussing privacy in the age of generative AI with Dr. Tom West, who is the Programme Director and Legal Officer at Privacy International. Tom, thank you for joining us on the podcast. Can you tell us a bit about Privacy International, about your role within the organisation?
Sure, thanks, David. It's great to be here. So Privacy International, we're an NGO. We're based here in London, and we work to defend the right to privacy and other associated and connected rights around the world. So what does that mean? Well, we look to fight back against intrusive practices, both by governments and by companies, identifying, exposing, challenging those practices where we think they threaten privacy, where they threaten people's freedom, threaten their autonomy. I guess inevitably a lot of that work is about technology and how we interact with it, including the new and sort of emerging tech that we're talking about today with AI. But look, we're not technophobes. It's important to say. We want technology to empower people, to empower communities. There's all sorts of ways in which it can do amazing things for us. So that's the privacy part of us. We're also, like I say, international. That means we work with partner organizations in, dotted all around the world and a range of different countries. And that really brings different angles and dimensions to the work we do. We'll be talking about GDPR today, I'm sure. Well, not everywhere in the world is there a data protection law of the same, or at all, or of the same breadth and depth as GDPR, and the issues that are different. In terms of my role, as you said, I'm Programme Director of our work on corporate exploitation, and in that role, I oversee our work challenging companies and their exploitation of data. So that can include things like workplace surveillance and the use of automated decision-making at work, big tech mergers, inevitably GDPR, I've already mentioned. But I also am a legal officer, and in that I participate and contribute to our other projects across the organisation. So just as a sort of taster, at the moment, for example, I'm also supporting some work we're doing with a legal challenge to the recent UK government purported or reported issuing of a technical capability notice to Apple, which listeners might have heard about. Do go and have a look. It's very interesting. And I'm also doing some work looking at digital health tools, so apps, wellness apps, and so on and so forth, and thinking about what mechanisms should be in place before those can be used, whether directly through sort of public healthcare providers or released onto app stores.
Thank you. You've spoken about privacy law very broadly in terms of the work that Privacy International does. You've mentioned GDPR. If I can ask you, Tom, about the efficacy of the existing law in this jurisdiction, do we need more law to deal with generative AI, or is it the case that the current laws are adequate, but it's just that they're not being used properly?
Look, GDPR is, I suppose, the cornerstone, right? It's a really important law. And what's, I think, really important about it, and we see that here, is it was designed to be technologically neutral, to apply to new techs. Certainly I didn't think about this, advent of generative AI at the time when GDPR was being written. I don't know what was in the drafters' minds, but it was intended to be able to apply in this future. At the same time, generative AI, look, it is an innovative tech. It does pose new challenges, and that is testing the application, the elasticity of how GDPR, its rights and principles can apply. And I think we are still at a point of working out exactly how some of those important rights principles are going to apply. And that does leave at the moment somewhat perhaps of a gap of rights on the paper of the GDPR and what we're seeing in practice. So if I can give just, I guess, some examples of that, perhaps the starting point is some people have referred to as the original sin of generative AI, which is the fact that, as we all know, they've been trained based on enormous amounts of data, often scraped from the web. And look, our view is that has almost certainly, in many instances, been done in breach of the GDPR without making sure there was an adequate lawful basis for that training. It's a pretty big problem. We also need to think about important principles that underpin GDPR: the need for transparency, the need for fairness, the need for data minimization, and thinking how those need to apply here. So I guess, as well as saying it's important, we do need to work hard to make sure that GDPR remains relevant. I'm also not surprised that we're seeing things like the AI Act in the EU, or these discussions around what to do about AI and copyright here in the UK, to tackle some of the more specific issues. And those may well prove to be needed as this technology and our understanding of it develops.
Taking it outside this jurisdiction, but still keeping it within Europe, if I can ask you, Tom, about the decision of the Data Protection Authority in Italy at December of last year, who fined OpenAI over 15 million euros to do with data protection breaches concerning the operation of ChatGPT. And it's also made a recommendation, which I'll deal with shortly. But the breaches came under four main headings. Firstly, there was a lack of legal basis for the processing of personal data that was used in the training of the LLM, the point that you were just talking about. Secondly, there was inadequate information on processing provided to data subjects at the point of processing. That's the Article 13 breach. There was a lack of age verification tools. And fourthly, the data that was training the technology was held to be inaccurate. The outputs were held to be inaccurate. And those were the breaches. Then there was also this recommendation that OpenAI conduct a public awareness campaign. And the statement that was made by the authority at the time was as follows: ChatGPT users and non-users should be made aware of how to oppose the training of generative artificial intelligence with their personal data, and therefore be effectively placed in the position to exercise their rights under the general data protection regulations. Now, it's important to caveat this with the statement on behalf of OpenAI that it will be looking to appeal this decision. But looking at the decision, the fine, and in particular that statement to do with public awareness, I take it this is something that, from your point of view, on behalf of Privacy International, you would welcome, Tom.
Yeah, I mean, I think absolutely the need for greater transparency and greater and better communication with the public around how AI works and what it does is really important. The Guarantee, the Italian DPA, is often at the forefront, I suppose, of some of these charges, and it's good to see DPAs that are willing to take on these sorts of challenges. But again, to the UK, we see the ICO late last year bringing out guidance, which it communicated with the headline of generative AI developers need to get much better at transparency. And that's important in and of itself, so people can understand what's happening. It's important because it's part of the GDPR. But that point that you were talking to there about saying how it can facilitate people to actually exercise their rights, that's absolutely crucial so that people are involved and can understand a process which otherwise can seem frequently very mysterious. Like I was saying at the start, we want to see technology being used in a way which empowers people. It's not something which is being done to them, which they have no agency, no control over. That's often when technology is failing people because they're not brought along on that journey. I think another interesting part on the transparency kind of side of things as well, David, is thinking about the ways in which AI companies sell what they're doing. Now, of course, there are times when people want to, big up what their products can do. But I think it's need to be very careful to make sure that some of the claims that are being made are realistic. There's examples out there of sort of AI chatbots which are describing themselves as things like counselor bots, and they say, well, hang on, this isn't providing sort of that kind of service. And so being careful about what the outputs are as well will be important. So yeah, interesting to see that the Guarantee took that point on as well. I mean, this is inherent to the technology of how generative AI works. Its outputs are probabilistic, right? They cannot be entirely controlled. And that's one of the sort of interesting things which leads to having to think in new ways around how the existing law must apply.
I think, in fairness to OpenAI, we should also say that the same DPA in Italy blocked the DeepSeek artificial intelligence technology that was launched by two Chinese-based companies at the start of 2025, and it was extremely quick in doing that, and that's currently under investigation. But it's an interesting point, it seems to me, Tom, because faced with these very new, innovative, powerful technologies that promise to do all manner of things in the way that you just suggest in terms of chat and health bots, we fall back on the basic rights that we have for data subject access under the GDPR. And those rights, of course, are demanding in what they require of the recipient. Do you have any knowledge or experience of data subject access requests that have been made to generative AI companies within this country and what the outcome of those has been. I say that to declare my hand. I haven't made a DSAR of OpenAI or anyone else to find out what it might have to say about the personal data to do with me.
It's an important question because these are important rights. I want to say for certain exactly things took place here in the UK, but certainly people have done it. People have sought to DSAR AI companies. The results have been mixed, disappointing perhaps at times. Often, or at least at times, the results have been people being given back their sort of account details. So, the name and the email address they've registered with to use the service. But of course, what's almost certainly of much more interest, and certainly we think of more interest, is things like what training data has been used, and also what personal data is contained in the model itself. And this again comes to this interesting point about the way in which AI is posing new challenges for the law. There was some talk at some point, I think last year, questioning whether or not actually generative AI, because of how it works, whether or not it was in fact actually processing personal data in the same way. I'm pleased to say that that conversation seems to be over and resolved in the very fact that yes, they are. That is the case. That is what's happening. And the EDPB, the European Data Protection Board, had some guidance which looked at that issue late last year. But this gets to the point of training data, and AI companies have been, I think, famously reluctant to give much information around what data has gone into these models. And that's problematic. It goes to the point we've already talked about on transparency and informing people. How can someone know that their data has been scraped off the web and used to train these models? We're not being told it. And even if we are going to be told it, there's also a really interesting question about how that can be communicated effectively. So this question of how can generative AI engage with important rights, things like DSAR requests, I think we do need to think carefully. And I think both AI companies and DPAs need to work out what that needs to look like here. I don't know if you've seen, David, examples that have been out there recently of occasionally it crops up where you can ask a chatbot, you can say, can you say David? It will say, yes, David. And then you can say, and I think the big example of last year was, can you say Mayor? And you've got to say Mayor. Can you say David Mayor? And it sort of blanks and goes, oh, I can't do that. And there's a few different names that has applied to. And I mean, people suspect this is because someone has said, please, can you stop sending out information about me? But that's such an incredibly blunt way of dealing with that request for such a sort of high level innovative technology. To have that absolute blanket all or nothing approach doesn't feel like that's the final answer.
Yeah, it's possibly the end of the processing, isn't it, rather than the start. People are interested to find out what went in at the beginning.
Yeah, and what can come out as well. What goes in and what comes out are important. And of course, what can come out, this can be a matter of data being extracted from the training data. And again, famously, some of the copyright cases, have demonstrated the possibility of that, certainly in the past. But it's also possible that data will come out which is incorrect, hallucinated, or data which will come out which has been inferred. And all of these pose different risks that, I think we do need to think about in terms of the outputs to the models as well as the inputs.
And broadening the discussion out a bit, if we may, Tom, we've covered competition law and environmental law in other episodes on this podcast. But if I can ask you, please, from a privacy perspective, are there lessons to be learned from competition law when looking at generative AI and how it might be regulated?
I think there's certainly overlaps between competition law, privacy law, and the regulation of AI. We've seen a few different, the CMA and the ICO brought out sort of joint work on this front, and we certainly also have work which thinks about things from the competition point of view. And like in other areas, you have some issues with AI which are, same old, which are old hat, and some things which are new. So one thing which we think about and we talk about is obviously AI is technology which is highly dependent on the use of and the access to data. And that's been a business model which has been around for quite some time, right? There's been data brokers and all sorts of other ways in which access to large amounts of data has proved to be an effective business model, but one which can, in many circumstances, not necessarily work in the best interests of the people whose data that pertains to. So we see those sort of repeated patterns there in the way in which AI can layer onto that and potentially magnify some of those concerns, and also result in a further concentration or embedding of power and market control in those companies which have based their business models upon both access to and control of large amounts of data and involvement of large amounts of our lives. So, I mean, I think a really interesting recent example, which sort of, I don't know, unlocks some of this maybe, or at least sort of shines a light on those, is over in the US at the moment, there's a couple of cases between the DOJ, the Department of Justice, and Google, looking at Google's control over both in terms of its search business and also in terms of its ad tech, its advertising technology business. And in both instances, courts have said, actually, yes, Google does have excessive control over those. The one which is running slightly ahead is the search, and that's now moved on to consideration of remedies. Google, of course, are appealing all these things. One of the remedies suggested by the DOJ is for Google to sell off Chrome, its browser, and also a well-known source of large amounts of tracking data. And unsurprisingly, perhaps, one of the first sort of companies which said, oh, yes, we'd be happy to sort of take over Chrome's OpenAI, because they know that that's going to be an important source of data for them for the future. And so we see these issues coming up again. So this is about people's data rights, but it's also about people's consumer rights as well, and the choices that they have over the tools that are available to them. I'm sure many of the listeners are users of WhatsApp. Recently, I saw, and many others have seen, Meta AI appearing in people's WhatsApp. And I think you can see here. So my first response when I saw it was like, well, what's this doing here? What's AI doing within my end-to-end encrypted messaging service? I mean, they say, of course, that the data will be, kept separately and those sorts of things. But why do Meta want to push this new technology onto us in different ways? Well, of course, it's to make sure that they can actually continue to make use of their current position in the market and their current power. And those are also layered issues which we need to think about, I think, for generative AI.
Moving this to the environmental law context, and of course, just so the listener is aware, your background, Tom, is in environmental law. You have a PhD in international environmental law and human rights law, and previously you've worked for environmental organizations. Are there any lessons to be learned from the environmental field in terms of the regulation and oversight that could be applied to artificial intelligence, in particular generative AI?
Yes, my background is in environmental law. I suppose I'm interested in different ways in which questions of distributed power can happen. And there's conceptual overlaps between environmental law and some of the privacy law issues we're thinking about here with AI. So yeah, it's the distributed harms that you see within environmental issues. I think we can also see here cross-border issues. We need international responses. Perhaps a more theoretical one is actually the ways in which there are non-human entities within both of these spheres, which may well qualify for certain aspects of personhood or legal personhood. But in terms of more the sort of, I guess, the concrete and ways in which lessons can be learned, I mean, there's a few bits and pieces which I think pop into my mind. The first one is the importance of impact assessments and making sure they're being done in the right way. So environmental impact assessments are an important part of that law. And we now, of course, have data protection impact assessments, fundamental rights impact assessments, and so on. Making sure those are working right and are not simply box-ticking exercises is crucial. We don't want to have a situation in which this is a large amount of work which is spent going through the motions and looking at what impacts are without actually saying, well, what are the impacts we need to avoid? What are the risks which are too high? What do we need to stop here? So thinking about how that works, I think, is important. Another core aspect, I think, for environmental law lies in public participation and making sure that the public are involved in decisions which affect them and their environment. And I think that goes to this issue of distributed harms and saying, well, actually, these are things which can affect people broadly and widely. And so making sure that the public as a whole are involved and have a say in whether that's things which are affecting them on an individual or perhaps local level, which maybe might not apply directly with an AI, although I suppose if you had an example where a local council, for example, was looking to move some of its services over to AI, you could see that in a slightly more localized fashion.
Sort of resonates with the point made in Italy, doesn't it, about public awareness and people understanding the rights they have in order to be able to participate in the process.
Absolutely. Yeah. People need to be involved in these processes in order to make sure that they feel part of it, that it's not, again, something being done to them, but something which they're on about. One more, I think, principle or function within environmental law, which I think can apply here as well, is the precautionary principle. This is a long-standing principle of environmental law, which essentially says, even when you're not certain what the details of the potential harm will be, action is legitimate, right? It's sensible to take action to stop potential harm, in particular when that's, significant, before you know all the details. And clearly there are times within AI when that may well apply. And I think taking a slightly more precautionary approach at times and making sure that we don't always move fast and always break things could be the right way to go.
That leads us very neatly on to the last question, Tom, and it's a question which Catherine Apps KC, the other host of this podcast, and I have asked of all of our guests, and it's really to do with your feelings, good or bad, if you like, to do with generative AI. On a scale of 0 to 10, 0 being the most pessimistic, 10 being the most optimistic, where would you place yourself in terms of what you think about this new technology, Tom?
Well, it's a complex calculation, that, isn't it? There's obviously harms and benefits to weigh up, right? It's clear it's not all good and not all bad. And part of my job is to think about, the harms, the former, perhaps more so at times than the latter. But look, there are clear and obvious benefits to AI, in particular, I think in things like healthcare research and things like perhaps in sort of weather pattern prediction and so on and so forth. I'm not yet convinced we've seen, I guess, the killer app for the ways in which large language models and these sort of tools are really going to drive forward our economy, our society, our communities. I wonder what effect it's having on productivity already at the moment. So it's a long-winded of saying, look, the harms are immediate. We know about those now. There's bias, there's fairness issues. We've talked about transparency and privacy issues. There are, of course, also potentially deep-seated harms as well. So I'm going to be under 5. I think I'll go about 3, David. Look, I do think there are ways in which we need to think about how AI can help us both in our everyday lives and can help us overall. But we need to be really careful, both about those concrete issues which we talked about, but also, we're here talking, about Privacy International, and we talk a lot about data protection, but privacy is not just data protection. They're not the same things. And there are these perhaps more deep-seated ways in which some AI tools could be used to interfere with privacy in a deeper way, which interfere with how our personal lives unfold, which interfere with our decision-making. Let's not forget that in many circumstances, those are going to be big AI companies who have designed those models. And that intrusion into how we relate to each other, how we develop our views, how we develop our personalities, our connections, and so on, that can also constitute a significant interference with our privacy. Are we giving people more or less space to develop into who they want to be, who they can be? My view is we should be giving more people to do that, more space to do that. And design right technology can facilitate that. It can help us connect to people, learn new things. But if it's done in a way which isn't necessarily in people's best interests, then we can see perhaps more deep-seated problems arising.
Well, thank you very much, Tom. Thanks for taking the time to speak to us and share those insights and those very considered thoughts. And thank you to you, the listener, for listening. You've been listening to Dr. Tom West of Privacy International talking about privacy in the age of generative AI, interviewed by me, David Mitchell, on the 39 Essex Chambers podcast, AI and the Law. For further episodes, please go to 39essex.com or to all major streaming platforms and podcast providers. If you have any suggestions for other programs in the series, please contact us using the contact details on the 39 Essex Chambers website. Thank you very much for listening.